Anna Davey, who will be speaking to us about the obligations of expert witnesses.
Yes, thank you very much. And that was fascinating. Let me just bring up my correct slide. So before I start, I'm down in Melbourne. So I'd like to acknowledge that I'm presenting this short session from the lands of the Wurundjeri people of the Kulin Nation. And I'd like to acknowledge them as the traditional owners and pay my respects to their elders, past and present. If I just share my slides, my screen. So that the previous presentation was absolutely fascinating. And I'd just like to make a couple of comments, and I think this is why my slides went crazy, because while Catherine was speaking, I was quickly putting some more slides in, and I think that stuffed the whole system up, so I apologize for that. So I think she's hit the nail on the head with the fact that the forensic science in the Chamberlain case was flawed. I mean, we look back at it now and we shake our heads and think, how on earth could something like this have possibly happened? However, having said that, I think that the blame, if blame is what we want to do, and maybe it's not blame, but just looking back and learning from experience, needs to be shared. When you carefully read the report of the Royal Commission, it's clear that there was obviously serious issues with the investigation and also with the legal process. Now, I'm not trying to diminish in any way the flawed forensic science, but I do want to make the point that forensic science does actually operate in a larger environment, and we interact with investigators and we interact with the legal system. And if the investigators are not doing their job and they're not bringing items in for examination, or not having crime scene forensic scientists at the scene, well, then obviously the forensic scientists can't do their thing. The other thing, and I think it came out in those last couple of slides, was the fact we had a person who was saying that he was an expert, and I can't pronounce those words either, so I'm with you there, Catherine. But I think the legal fraternity, the legal system needs to take some responsibility, and I was really excited with that last statement that Catherine made about forensic science working so closely, or working closely with the legal community. And that's something that I'm very, very passionate about. And for those of you who I'm going to get to forensic societies and talk about that a little bit later in this presentation, but one that you might want to think about, and particularly if there's other legal practitioners online other than Catherine, is the Australian Academy of Forensic Sciences, because that's a body that has been set up to facilitate discussions between forensic science, forensic medicine, and the legal community. So I think what I'm doing now is following on very nicely from what Catherine was talking about before. So yeah, so I'll just keep going. So now for some reason, my slides are not going on. Why is this not progressing? Oh, there we go. So Catherine in her presentation talked about the Uniform Evidence Act and Section 79. And I think what we, as forensic scientists, we have to recognize is that we have an incredible honor to be recognized as people with a specialist knowledge. It's an absolute privilege to be able to present our opinions in court and have those opinions recognized with the court. There's not a large number of other categories of people who fall under the various exceptions of the Uniform Evidence Act. So I think sometimes we just take it as granted that we're experts and this is our job and this is what we do. We go to court and give our evidence. But I think that we've got to recognize that that's an incredible honor that the legal system has actually bestowed on us. We can give evidence about things that other people are not allowed to give evidence about. So, but as this diagram, this yin and yang diagram illustrate, with that recognition comes huge responsibilities. And we can't be anything but cognizant of the responsibilities that that privilege really gives us. So what I want to talk to you about this evening, just very briefly, and again, I could speak all day on this, but I won't. I'll try and limit it to a few slides, is, well, what are those responsibilities? What is it that we're supposed to do? And I think it's very important that we actually understand these. So what I've done is I'm going to cover basically 4 areas about where we can find out what are our responsibilities. Obviously, we all want to do a good job. We know we should be impartial. We know we should be accurate, but where can we go to get some guidance as to what the courts, the legal system actually requires? So the first one is statute or legislation, and also court rules, because all the courts have rules with regards to expert or opinion evidence or experts. I want to look at what the common law says about expert evidence or opinion evidence. I want to look at what some of the professional associations say, and I also want to look at the issue of communication. So just before I go on, what I want to do is say that I realise this is a presentation from based from UTS, which is in Sydney. As I said, I'm in Melbourne. But once students from UTS have graduated, they could end up working anywhere. All the states, territories in Australia have statute, have legislation, and have different court rules with regards to the provision of expert evidence. So you need to be aware that if you travel from one jurisdiction to another jurisdiction, the rules may differ. Now, the basis of those rules is very, very similar, but the words do change. Now, I've got some documents, if people are interested, where I've compared statute across the country and also court rules across the country. And all of that information is freely available on my website. So please use that as a resource. It's there, I've put it there specifically to be used. Okay, so first we'll talk about statute. So I'm going to focus on New South Wales. There are 2 pieces of what's known as delegated legislation. The first one is the Uniform Civil Procedure Rules, and the other are the Supreme Court rules. These are both available on the internet. You can get them whenever you want. And both of these point you in the direction of the Expert Witness Code of Conduct. Now, once upon a time, every jurisdiction had its own Expert Witness Code of Conduct, but now we have a harmonised code, which again, like the Uniform Evidence Act, has been adopted by some jurisdictions and not others. So let's just have a look at what the Expert Witness Code of Conduct says. Oh, I should say before I go on that although these are uniform civil procedure rules, they have been adopted in the criminal jurisdiction within the courts. So if you're doing criminal work, you're still bound by the Expert Witness Code of Conduct. So as I said, this the Harmonised Expert Witness Code of Conduct has been approved by the Council of Chief Justice's Rules Harmonisation Committee. I didn't even know such a thing existed, but apparently it does. I'm just going to focus on 2 sections of this code because it's quite extensive. And the first one is basically where the code applies. So the code applies to any expert witness engaged or or appointed to provide an expert's report and to give an opinion in proceedings or proposed proceedings. So basically, any report. So it's universal. It applies. The next point is probably the most important thing that any expert witness needs to know. I can jump up and down. I was going to put it in red. I was going to put it in bold, but it's really, really important. And as I said, as you travel around the country, different courts, different jurisdictions have slightly different rules, but one thing they all have in is words to this effect. An expert witness is not an advocate for a party and has a paramount duty overriding any duty to the party, to the proceedings or other persons retaining the expert witness to assist the court impartially on matters relevant to the area of expertise of the witness. Okay, so whether or not you're privately retained by a solicitor, whether you work for a government body that does forensic science, so in New South Wales, we'd be looking at the police, we'd be looking at, what's DAL's new name? Forensic Science Analytical, whatever they call themselves. Anyway, whatever DAL is now called. You might be called by the prosecution in the majority, if not all of the cases that you undertake, but your paramount duty is to the court, and the court is basically representing the community. Okay, so I can't stress this enough. It's very easy, and I can speak from experience because I've been a practicing forensic scientist for a long time, to get caught up in the case, to get caught up in the circumstances of the case. You know the people who are doing the investigation. But your paramount duty is to the court. And if what you find, what you say doesn't suit the party that calls you, well, to some degree, that's just bad luck. So just continuing on, I'm not going to go into these in any detail, but these are the other headings in the Harmonised Expert Witness Code of Conduct. It talks about what should actually be in your report. So it's quite extensive. And one of the reasons that it's quite extensive is that it is essential that your report is transparent and that all the information that is required by the people reading your report and using your report is there. They don't have to go hunting for it. They don't have to read between the lines, that everything is set out really, really clearly. There's also a section if you change your opinion, and there is nothing wrong with changing your opinion. It could be that you receive further information, you do further tests, and that the opinion that you formed previously changes in some way. That should read duty to comply with the court's directions rather than suity. So you have a duty to comply with the court's directions. There's also some information in there with regards to conferences of experts, and remembering that you're a witness for the court and not for the party that called you. These conferences can be so useful. If you think back to the Chamberlain case, I mean, that was back in the early 80s. We didn't have the sort of infrastructure in forensic science that we have now. I mean, the states and the territories really went their own way, and it wasn't until the National Institute of Forensic Science was actually formed in the late 80s, early 90s, I can't quite remember the date, that communication between forensic science organizations in the different states actually came together, and we got the communication that we've now got. The environment in the 1980s was very, very different. But talking about conferences of experts, you know, if we'd had a conference of experts, if we'd had the experts, the forensic scientists which were involved in that investigation, having a conference with other experts, some of these problems might have been highlighted and discovered much, much earlier. So that's the first thing I wanted to mention. And I'm just looking at the time. I don't want to go too long, but I can talk underwater once I start doing this. The next thing I want to talk about is common law. So as you know, common law is judge-made law, and we have the principle of precedent. So the piece of common law that I'd like to refer to is commonly known as Makita, and it's known as the Get Gold standard for expert evidence and opinion evidence. It's a very interesting case. I haven't got time to go into the details. It is a New South Wales Court of Appeal. That's where it was created. And if you remember about precedent, that meant that it was binding in New South Wales, but only persuasive in other jurisdictions. However, a very similar case, the Dasreef case, went to the High Court, and the High Court discussed the Makita ruling and upheld it. So because that's now the High Court, that's the highest court in Australia, it's now been adopted across the country. So let's have a look at what Justice Hayden said in Makita. And I'm going to go through this in detail, and I'd like you to just look at the dot points and think about how you would actually do this, and what's easy and what's not so easy to do. So he said, and I have to say this was all one sentence, I put the dot points in so to make it easier to read. In short, if evidence tendered as expert opinion evidence is to be admissible, it must be agreed or demonstrated that there is a field of specialized knowledge. Well, I think that gentleman that Catherine was talking about with the shape of the head, he might have fallen down there. There must be an identified aspect of that field in which the witness demonstrates that by reason of specific training, study, or experience, the witness has become an expert. So you'll see the words there, specific training, study, or experience. They're from the Uniform Evidence Act, which we've talked about before. The opinion proffered must be wholly or substantially based on the witness's expert knowledge. So I was a DNA scientist. I can't give fingerprint evidence, for instance. So far as the opinion is based on facts observed by the expert, they must be identified and admissibility proved by the expert. So if you're going to rely on something that you say you've seen or you've done, you need to be able to prove it. So far as opinions based on assumed or accepted facts, they must be identified and proved in some other ways. So it's very important when you're actually undertaking your work and you're forming an opinion that you can distinguish between observed facts and assumed facts. It must be established that the facts on which the opinion is based form a proper foundation for it. And this is where the responsibility lies. And this isn't easy, this next bit. The opinion of an expert requires demonstration or examination of the scientific or other intellectual basis of the conclusions reached. That is, the expert's evidence must explain how the field of specialized knowledge in which the witness is expert by reason of training, study, or experience, and on which the opinion is wholly or substantially based, applies to the facts assumed or observed so as to produce the opinion propounded. So it's not just a matter of us going into court and holding up our hand, and it's not that we actually do that, but hold up our hand and say, trust me, I'm the expert. We actually have to be able to take the court with us so we can explain how we got from A to B. If all these matters are not made explicit, it is not possible to be sure whether the opinion is based wholly or substantially on the expert's specialized knowledge. If the court cannot be sure of that, the evidence is strictly speaking not admissible, and so far as it is admissible, of diminished weight. That's a huge responsibility to be able to actually undertake that. So the next thing I was going to talk about was guidance that we can obtain from professional associations. Now, in addition to being forensic scientists or forensic practitioners, we're also often members of other organizations, other professional bodies. So it's very important to be aware and cognizant of codes of ethics, codes of practice of all those societies that we belong to. All right. One that many of you hopefully will be a member of is the Australia-New Zealand Forensic Science Society. And as you know, there is a code of professional practice for all members of the Forensic Science Society. So I'm going to leave it there. I'm not going to, because of time, I'm not actually going to go into the details of what the code actually says. You can look that up yourself, but just be aware that that code exists. And the last slide I have, I'm talking about communication here. We have a responsibility to be science communicators. I love this slide. It indicates the difference. We can be talking to, and it's not just lawyers, it's also the investigators, it's also the general public. Scientists, every profession has its own lingo, its own slang, its own way of thinking about things, its own thought process, its own accepted practice. And so when we're talking and describing what it is we're doing, it's so easy to take shortcuts because a colleague would actually understand what we were saying without having to actually elaborate. Whereas when we're talking to somebody from another profession, we've got to ensure that we're not taking those shortcuts. And one of the real skills of a really good expert witness is actually to be a good communicator and a good science communicator, and be able to break things down, concepts down, numbers down, processes down, sometimes very, very complex scientific processes into terms which are not incorrect, because we don't want to be incorrect, but are digestible to an audience that isn't familiar with these concepts. You might be interested to know that the average, or the chronological age, reading age, sorry, not chronological age, the reading age which a lot of the newspapers, so in Melbourne it'd be the Herald Sun, I'm not sure what the equivalent is in New South Wales, but with Courier Mail in Queensland. The reading age of those papers is it's upper primary. And although people, you might have, I'm just thinking about the jury here, you don't know who's on the jury. You might have people who have had very little education. You could have people who have had extensive education, but not in science. The lawyers, the majority of the lawyers, and this is no disrespect to the lawyers, because they're extremely well qualified in what they do, and I stand in awe of a lot of them, but a lot of them haven't done science, or if they've done science, they stopped at like year 10. So they need, you need to be a really good science communicator, a really good communicator. So that's all I want to say about that. I've put my contact details here. So please, anybody feel free to contact me. I'm more than happy to expand on anything I've said. Have a look at our website. There's a lot of resources on our website. And I'll stop now. I'll try and stop sharing my screen, and I'm happy to answer any questions.